I was very, very moved by the testimony or the remarks today by the lives that were touched by your vicious criminal act. And I wondered, to what extent did this man even think about these things? Was he so wrapped up in himself that it didn't even matter to him the effect it would have on the people who loved him? So if I got into the issue of deserve, that would certainly be at the forefront. I will say that you have been cooperative throughout these proceedings. You did not contaminate this courtroom by giving perjured testimony, which a very large share of our offenders do. The degree of planning of the crime and the concealment is very concerning, and speak to long-term determination of lawless behavior. On the first count of the information, it is the sentence of the court that your custody be committed to the Department of Corrections for a period of 2 years, followed by a 2-year period of extended supervision. On the second count, for an identical sentence to be served consecutively. On the fourth count of the information, hiding a corpse, for a period of 6 years of initial confinement, followed by 5 years of extended supervision, to be served consecutively to counts 1 and 2. And on the third count of the information, it is the sentence of the court that your custody be committed to the Department of Corrections for confinement in the Wisconsin State Prisons for the remainder of your life. This sentence is consecutive to and not concurrent with the sentences on the other 3 counts. The period of eligibility for extended supervision will not occur until 40 years following the date upon which you start the sentence on count 3. You have rights to appeal with respect to the disposition of this case, and your attorney will review them with you. If you understand your rights, tell Ms. Muller. She'll have you sign a document acknowledging that. If you don't understand, tell her. She'll bring you back in here for further instruction. There's a copy for you as well. Persons convicted of felony, as you have been, are ineligible to have firearms in their possession. That is a lifetime prohibition, and unless you have a permit from the Secretary of the Treasury, you may not have a firearm in your possession at any time for the duration of your life. It is a serious state and federal crime for you to do so. There is credit to be allowed for 1,092 days in custody to be applied to the sentence in the sequence 1, 2, 4, and 3. All sentences, as I think I indicated, are to be served consecutively to one another. The conditions of its extended supervision, I think I'm actually going to withhold any action on that on the supposition that there will be no extended supervision until he's 95 or thereabouts. And they can best be addressed well,
They're going to ask, they're going to require.
you know what, I think you're right. Although I did do one and it didn't, and it hasn't come back yet. You'll abide by all rules and regulations established for you by your supervising agent, pay the costs and disbursements of this action, repay to the, well, that one, no. The matter of restitution is to be referred for examination by court commissioner and return to the court with recommendation within 60 days. You're not to a firearm, I did that already. No contact with any member of the those who are statutory victims in this case, except as is allowed by your supervising agent. Any other conditions requested?
No, thank you.
Anything else?
Judge, as far as the, I just want clarification on the no contact with those considered to be victims. I know that OA has been categorized in that way in this case, and naturally, I guess the clarification that I want is that was the no contact that was just discussed had to deal with if the individual was released, that would be a condition of the release. But while in custody, is there going to be a no contact order issued?
I'm not aware that I have the authority to issue any order on that.
And I would agree, Judge, I just wanted that to be clear on the record.
I'm not imposing any order on that. I think that's a determination to be made by the Department of Corrections. Do you disagree?
Well, Judge, I think you do have the ability to make that order because there is a crime for contact after conviction, violating a court order. But my understanding is OA is not requesting for a no contact.
I've had a chance to speak to her in court.
Okay.
She's not requesting that.
Okay. I'll leave it as is then. Anything else?
Yes, Judge, one last thing. A proposed order was submitted to the court on behalf of Mrs. Patterson regarding this court, given the verdict by the jury, ordering the medical examiner's office in Kenosha County to produce a death certificate.
I got a letter. I don't recall seeing a proposed order.
It accompanied the letter. So the letter came through and the order came through directly after it. I believe it was end of April, or April 28th. Yeah, the letter was from Attorney Capper.
Right.
Judge, I would ask that that be taken up at the restitution hearing. I think that's a more appropriate time to address that.
Well, I don't know why, because the commissioner is making a referral only to examine the circumstances regarding restitution. I had the trial here, and the fact of the death of Mr. Gutierrez was an essential ingredient of the conviction, and so nothing the commissioner can report can change that fact. But I was on vacation last week, so I got that just before I left, and I did not see the proposed order.
I did not see a proposed order. I see the letter, but there's no proposed order.
If we get you a copy of an order, will the court sign it?
And I did when I got the letter, and I was. He refers to a. No, I don't even know if it does. I did not see a proposed order, and I did do a little bit of checking.
They imported it as an order. They imported it as a document, so the judge would not have even documented. They didn't import it.
And I will tell you, is there a statutory process for this? And I, frankly, my intention was to start by calling the registrar and ask if they have a procedure that they would like followed on this. And if statutorily compliant, follow that procedure. If they don't, then
I guess, Judge, where the defense thought that it would be more appropriate for a different venue to hear that is it is a civil determination. I too was trying to do some research on it. Granted my young age, and in the homicide cases that I've worked with Attorney Birdsall and Attorney Aubert, and on my own, I've never seen that determination for that purpose be done by the criminal court. It's always been a separate civil proceeding. So I wasn't able to complete or find definitive answers in my legal research, but my position, just based on the type of finding and why it's going to be used for, is a civil finding that I don't think should come from the criminal court proceeding over the criminal case. I think it should be a different court and make an own separate finding based on the finding in this court of the declaration of death.
well, I don't know. I do know that the conviction on the third count requires a proof of the death of Mr. Gutierrez and at the highest burden of proof. So I don't think I don't have any conceptual disagreement with this court making such an order, but I'm going to ask that you confer with Mr. Cafferty, Ms. Krasaric, and also with the registrar to see if they have a form order that they would like to have, because as Mr. Gravely has so aptly pointed out, talking about the restitution or the extended supervision, it'll come back. So let's see if we can get it right the first time. So I'm not going to do anything at this point, but if you can report to me what you find out, and to Ms. Muller.
Thank you, Judge. I appreciate that.
Okay.
I do have CR 233, the Notice of Right to Seek Post-Conviction Relief Form. Perfect.
Okay. Thank you.
So all four counts were consecutive, correct?
Each consecutive to the other.
Can our people be excused?
I think you're going to be with him for a bit? Yeah, yes. I'm going to ask folks if you'd be kind enough. No. Let me ask that those